What would have been brave if I'd taken a stand 30 years ago.
Oh my god, shut up. Hi there, my name's Leja. I'm a real-life lawyer on a mission to demystify the law and how it affects your everyday life. Today, I'm gonna react to an episode of Law Order. Again, I already did this once, but I got a lot of flack because I apparently didn't pick the right episode. But then every person that commented saying pick a better episode didn't really give me anything to work with. So I'm doing my best here, people, okay? The episode that I picked last time was off a list that I found on the internet of best Law Order SVU episodes, so your gripe is with that website, not with me, okay? But because people seem to still enjoy what I have to say about that episode, despite the naysayers, I thought I'd watch another one that's a little bit more recent, because it deals with things that have been more recently in the headlines, as Law & Order likes to do. So I'm going to watch Season 22, Episode 6, The Long Arm of the Witness. Before we get into this, let me say that I'm a lawyer, but I'm not your lawyer. Nothing that I say should be construed as legal advice, and you should always seek the advice of a licensed attorney before making any legal decisions. Okay? Let's watch. Let me just preface this whole episode by saying that this deals with a lot of sexual assault, sexual violence, so content warning there.
You claimed my client groped you on the dance floor?
Yes. I had to smack him away.
With one hand, because your other hand was holding a vodka and soda?
Now, okay, that's where you would say objection, relevance. Come on.
Objection. Valentina Palmer isn't on trial here. Ian Hunter is.
There we go.
I didn't feel safe taking the subway to the Bronx.
And did Ian drive you home?
Yes, but to his house, not mine.
To his parents' house in West Hampton? Why didn't you tell him to turn around?
Okay, so, I mean, I say this, I think in every single one of these reaction videos, but like every movie, TV show, they are just obsessed with having the attorney walk back and forth in front of the witness stand, talk to the jury, talk to the witness. Like, I was confused there for a second because she was facing away from the witness as she was questioning her. Like, so weird. That's not how it works. The witness sits on the witness stand, the attorney stands at like the podium or some sort of designated space for asking questions of a witness, and then asks questions. She seems to be kind of attacking this witness, and the witness's attorney should definitely be objecting to badgering the witness.
It wasn't sex. I said no.
No to getting in his car? No to going in the house?
This again, what is this guy doing just sitting there? The question is not what she said no to, but prior to the sexual encounter, the question is, did she say no to the sexual encounter? It was not consensual, therefore it was rape. Let's actually look at how rape is defined in New York law, because I believe this is in the state of New York. Lack of consent is an element in every criminal sexual act. It results from force or threatened use of force or incapacity. Mentally incapacitated means a person is rendered temporarily incapable of appraising or controlling his conduct owing to the influence of a narcotic or intoxicating substance administered to him without his consent or to any other act committed upon him without his consent. That incapacity to consent is due in part to the imbibing of substances, meaning that if she was under the influence, she didn't have the capacity to consent. Therefore, whether or not she said yes, even if she said yes instead of saying no, she did not have the capacity to say yes. And the fact that she said no makes this an even stronger case. The problem with things like this is that they're between two people. There was no witness to this encounter in this instance, so then that makes this a he said, she said situation, which then leaves it up to the jury to determine which of the two witnesses, him or her, is to be believed as to what happened. But based on her story, it sounds like she falls within the confines of this New York rape law. And so whether or not she said yes to getting in the car, etc., is irrelevant, and he should be objecting.
I have no way of knowing what actually happened that night, but I do know that I can't let this court cavalierly destroy Mr. Hunter's future. I've heard the evidence presented by the prosecution, and I find it legally insufficient to establish the offense charged therein. Therefore, I am granting the defense motion to dismiss the indictment.
Okay, so basically what just happened is that after a case is presented, a party can move that the judge make a ruling before it ever goes to the jury by saying that the prosecution did not even lay out the basic elements of this claim such that it can be ruled that it should be dismissed without the jury ever hearing it. This is called a JMOL, or a judgment as a matter of law. Basically, the defense is saying the prosecution has made no showing of its case. There is no evidence to support its case such that a jury could never find in their favor, and the judge can say, you're right, no jury, no reasonable jury could ever rule in favor of the prosecution in this case, so I'm just going to make a judgment before we submit it to the jury. Because you saw there's a jury sitting there, so there was a jury there in front of the case, but the judge made a determination without sending it there. This, however, in this case seems really impossible. Like I was saying, this is a he said, she said type situation, so as long as she said, I was under the influence, I did not consent, he took advantage of me, he raped me, that should be enough to at least hit all the elements that a judge would not just rule in the defense's favor. That would go to the jury, because the jury is what's known as the finder of fact. And here there appear to be many questions of fact. Was she in fact intoxicated? Did she in fact say no? Was it consensual or not consensual? These are factual questions that a finder of fact, meaning the jury, should be the one to make the determination. Because there were enough questions of fact that a jury could go either way on, it was really inappropriate for the judge to even grant the motion to begin with here. And this would likely never happen, and even if it did, I think there would be really easy grounds for appeal here, because clearly there were questions of fact outstanding that a judge should not have reached a conclusion that there was just no case made at all. I will say though that, as we've seen in many of my videos throughout this channel, there is a lot of bias in the judiciary. There are bad judges, there are many amazing judges, and I would say most judges are pretty good at keeping a pretty balanced approach to things. However, there are a handful of judges that are just kind of unethical. See my video on the trial of the Chicago 7, that is a actual depiction of how a judge acted in a court of law. So that's why the appeal process happens, because if there's a miscarriage of justice, as we just saw here, they can appeal it. However, I will say, in cases of sexual assault like this, just getting to trial, just a basic trial like this as a survivor of sexual assault is traumatizing in and of itself. It's re-traumatizing. It requires you to live in that moment for a very long time, because getting to this point in trial probably took at least a year after the actual event occurred, and so it's nearly impossible to even have any sort of ability to move on with your life when you are trying to prosecute your own rape case. So the fact that now this happened and they have to go to appeal is going to add at least another year, probably more than that, to this saga, unless she wants to just say, screw it, I'm done, I give up, which is what happens a lot, because the system is stacked against actual justice, and it's a lot harder to prosecute than it is to just try and move on with your life.
And then he declined to prosecute a white college male in a he said, she said.
The old boy network is strong out east.
So is the corruption.
The fix was in before all rise.
That's pretty much what Calhoun told us.
Ice-T with the one-liners. He's been serving up one-liners on this show for the last 2 decades, and it never gets old.
Head of the Civil Rights Unit? It's a big step up.
Oh, well, after the riots, they needed someone, what did my boss say, who checked every diversity box.
If, in case you recognize him, he was in Prison Break. Wentworth Earl Miller III, an English-born American actor. He was born in Chipping Norton, Oxfordshire, England, to American parents. Miller said in 2003 that his father is black and his mother is white. His father is of African-American, Jamaican, German, and English ancestry. But, like, would we say this guy checks off every diversity box? Would we say that?
Brilliant girl who was so brutalized by Gallagher, she dropped out of Hudson. It's haunted me because I didn't help her.
So you're saying that he raped her?
She told me he raped her while Tommy Burns held her down.
Did she report this?
She did, but those days it got buried. Gallagher went on to Harvard Law, became a judge.
And the victim?
Not a week has gone by without my thinking about what Chip did to her.
Okay, like, that's very dramatic, Mr. Wentworth. I'm sensing some male guilt going on here. It's gonna be extra dramatic and take away from the actual plot. Isn't that how it always works?
Thanks for calling.
Wasn't my idea.
Well, thank your daughter.
Went through some old boxes in my garage, found a bunch of old memo books, but...
I didn't get them from you.
And his other 2 victims I found, you didn't get those from me either.
Okay, so in this situation, this guy would probably be considered a confidential informant, meaning someone that the cops are using to establish evidence, mainly probable cause, for a crime in this case, potential rape. So confidential informants are very frequently used by law enforcement in order to obtain information. A lot of times informants want to remain confidential for a number of reasons. Their own safety, they don't want to self-incriminate. However, in order to use a confidential informant, there has to be a certain amount of oversight. A lot of times they have to go before the court in an ex parte hearing, meaning it's not part of the actual trial itself, but they do have to go before the judge so that someone can confirm whether or not they are actually a reliable source. The issue here is reliability. We want to make sure that these informants that the cops are using actually have a good basis for the information they're supplying, such that they can be relied upon to create probable cause. We want to make sure that the cops just aren't fabricating some random person and saying, well, it's a confidential informant, and then not having to follow through on that. This guy doesn't seem like he really wants to be involved at all, so I do wonder whether he really knows the process. Also, he's handing over physical evidence, documents like that were kept during the course of business. If they are going to be produced into evidence in a trial, they tend to need to be what's called authenticated, meaning that the person who wrote them or someone with actual knowledge of the documents has to go before the court and say, yes, these are the actual documents that I wrote in the course of my business as a campus police officer. So I don't know whether he's aware of how embroiled in this he's going to be, and it's not really realistic that someone who is a confidential informant could just like drop some evidence on a bench and then walk away and never have to be involved in the case again.
You should be very proud. Girl from the pink houses.
I am. I had a choice between failing his class or acing it with a law school recommendation and a clerkship that led to this job.
You don't need me to tell you that that's rape.
Maybe rape 3. But that's a tough case, and it might put my partnership at risk.
Maya, I can't tell you what to do. But I've never known a sister from Brownsville that would step away from a fight when someone had done her wrong.
This is really complicated, and here Ice-T is just trying to pressure her into making this really huge decision. I think it's understandable why she's clearly conflicted about this.
This isn't an investigation. It's a political inquisition.
Rita, you can spin this any way you want. We found these women. They didn't come to us.
And the DA is willing to go to trial on this tomorrow.
Correct me if I'm wrong, Counselor. You went to Fordham Law Night School. You've been a ADA for a year.
Hold on.
Fordham Law is still a good school. These fucking Harvard guys, I'm telling you. I went to law school in Boston, not at Harvard. I definitely met people that went to Harvard, and there's many nice people that went to Harvard for sure, and other Ivy Leagues, but there's definitely, especially if you're a white guy in there, there's a level of just kind of entitlement. There's a level of exclusivity. There's just this like obsession with prestige in the legal field that is like kind of being embodied by this character that I think is rubbing me the wrong way, because it's something that I kind of had to fight against because I didn't get into a big fancy Ivy League school, and I'm still smart and have a perfectly good legal career, and that doesn't mean anything about like my personality and my character and who I am as a person and what I'm worth. But it's really easy to let yourself feel that it does, because it's kind of what the whole law school and legal field system wants you to think, because it's run by people like him, people like the Brett Kavanaughs of the world that think that they're entitled to where they've got in life, and that it didn't come from a lot of privilege and a lot of connections that they didn't do any work to make. And it serves the higher ups, the prestigious people, the Ivy Leaguers, if you continue believing that there's a level of prestige in that people who go to schools like that are better attorneys, better people, worth more. They're the only ones that benefit from it. Every one of the rest of us who weren't in an Ivy League, we're the ones who suffer by buying into the prestige of Ivy League schools. I believe there's a clip of Michelle Obama giving some talk where she says, you know, I've sat in rooms with some of the most powerful people on the planet and they're not that smart. And that's kind of how I've felt as I've navigated my legal career. Of course, I've worked with a ton of really smart people that I really, really respect, but just because you go to law school, even a prestigious one like Harvard, does not mean that you are necessarily smarter or better at the law than other people, and it certainly doesn't mean that you're better generally or worth more than other people. However, there are people like this guy, as much as he is a caricature of the Brett Kavanaughs of the world, there are people like him who believe themselves superior to others because of their pedigree of the schools that they got into, likely by either happenstance, good luck, or privilege that they were born into. So that's my whole spiel about not buying into Ivy League or prestige in any way, because I think it's a bunch of bullshit that mainly hurts all the people who didn't go to Ivy Leagues, which is most of us.
See, don't you let these bastards get to you. You got this.
I'm a little unclear what crime they're prosecuting in this trial. I think it might be that junior partner's rape, because she said it was like 10 years prior, and the statute of limitations is like 20 years for second-degree rape. So I think that's what they're trying. They're not really clear. Like, they didn't have an arrest. They didn't have, like, I'm very unclear what crime they're prosecuting right now.
Ms. Giamba, you've been married twice. No. I'm sorry. 3 times. I don't see a ring on your left hand.
All right, that would be, hello, objection, relevance. We're talking about a rape. We're not talking about her marriage.
Action.
Prosecution is using this woman as a Molyneux pattern witness. I'm merely showing a pattern of deceit that this witness cheated on 3 husbands she promised to be faithful to.
Ms. Calhoun, the objection is sustained.
I don't see why the jury should take her word against my client.
Okay, this is very inappropriate lawyering. You ask a question, the other lawyer says objection, you stop talking, you wait for the judge to rule. If the judge sustains it, you can't keep going, and you certainly can't start talking and rambling and telling the jury things and arguing with the judge. Like, no.
Nothing further.
That's her whole cross of the witness. When you get up and you cross-examine a witness, you're supposed to ask them questions that raise doubt in the minds of jurors as to their story and their credibility. Here, again, she was asking about the marriage, which is what she was trying to get at. She was trying to say that, I don't actually even know what she was trying to say. That she's been divorced 3 times. What does that even say about her character, you know? Like, she should be getting up and asking, you know, like, were you drunk? Is your recollection potentially inhibited because of that? If she has any history of lying, or there's proof of her being a liar, like, she can bring that kind of stuff up. But mentioning that she's been divorced 3 times and saying no further questions, that's crappy lawyering.
I looked up to him. He seemed to take a special interest in me, even though I was on scholarship.
And what changed your relationship?
He seemed to take a special interest in me even though I was on scholarship. Like, are people at other law schools being discriminated against based on their financial status? I don't think law professors know whether or not someone's on scholarship. That's a weird comment. I don't think that's accurate. I don't think that happens at schools anywhere. I mean, comment below if I'm wrong.
But if I wanted good grades, a recommendation, I had to, as he put it, approach the bench.
Oh.
By that he meant service him sexually.
And did you?
Yes. The first time that night. I subsequently had night court with him. His phrase for oral sex.
This guy really likes a disgusting law pun. Usually I'm behind it, but not in this situation. Also, she said good grades. If I wanted to get good grades. No law professor has this much control over your legal career. If he's her professor, then she's taking 1 class from him. So that's a grade that he could be kind of holding over her, which is still bad. But the narrative that her entire career depended upon him is not accurate to how law school or your legal career works. You have many professors. You get many different grades. 1 grade can be outcome determinative of your future. So I'm not saying that this isn't relevant and wouldn't be horrible if a professor was doing this. I'm just saying 1 professor doesn't control everything, you know?
If I didn't do what he wanted, he wouldn't just fail me. He'd see to it that I would lose my scholarship and be expelled. 1 phone call, and my hopes of a law career would be dead and buried.
Okay, so he controlled 1 of her grades, but he was threatening to, like, derail her entire career. I wonder if that would work. I wonder if 1 judge, 1 person has enough clout to see to it that she would have her scholarship revoked and get expelled from law school. I don't really know what that would take. But, you know, he's a powerful guy. He's got a lot of influence. You never know, so.
Assume you know the penal code for prostitution in New York State?
Yes. And I know where you're going, and this is not...
Her lawyer should be objecting. This is not relevant. She's not on the stand. She's not on trial right now. Like, objection.
Would you please read aloud this email that you sent to Judge Gallagher?
Chip, a note of thanks for all you've done for me. I began my clerkship today, and I never would have made it here without your support.
Does that sound like the kind of note that a victim sends to her rapist? And didn't he write a recommendation to the firm where you are now a junior partner?
Yes, but that doesn't mean...
Your testimony seems to me like nothing more than an ambitious young woman looking to hustle some free Me Too publicity.
Objection.
She's asking these hypothetical questions. She's insinuating a lot. She's not just being straightforward about it. Like, there's a lot of things to object to here. Again, you can't just like start talking and say things to the jury like that. Like, you just are there asking the witness questions. You can't like then say like, this is just you trying to get Me Too publicity. Like that's completely out of order.
I don't want Gallagher to get away with what he's done. I'll testify.
You can't have surprise witnesses in trial. If she was gonna testify, she would have had to agree to do it a long time before this. I mean, I guess it could be a maybe situation, like they told the other side that she might testify, but it kind of seems like she was completely out of the picture, not prepped, not part of any part of their case because she decided not to, and then she just shows up on the day of the trial and says, I'm gonna testify. Like, it doesn't really work like that. There's a lot of witness prep that happens ahead of the trial. You have to disclose who are gonna be your witnesses to the other side. You can't just spring this on them. Not realistic.
Didn't campus police interview 2 of your friends who said they saw no rape?
They weren't in the bathroom.
So in this situation, she wouldn't be able to say, didn't they interview your friends who said X? That's not entering it into evidence. If she wanted to enter this woman's friends' interviews into evidence so the jury could take it into consideration, she would have to actually present it, either by calling them as a witness, by having deposition testimony from them, by having some sort of written record of what they said. An attorney can't just stand up and, as part of her questioning of a witness, enter something like, your friends said they didn't see anything, into evidence.
And so you did not support April's accusation?
No. To my lasting shame.
And even today, is testifying against the sitting judge, a candidate for state attorney general, a good career move for an assistant district attorney?
I wouldn't think so.
So why are you testifying today?
I am trying to right the worst moral lapse of my life. My silence. My failure to come forward on April's behalf haunts me to this day.
Did I call it or did I call it? This has now become a complete narrative around this random guy's guilt that he feels for not protecting this woman. Like, we're not even talking about April. We don't know anything about April. We're like, she testified for a little bit, but the number of shots we've had of this guy being like, to my lasting regret, I did not stand up and protect her honor. Like, come on, this is what happens every time. It's like white guilt, male guilt, it overshadows the actual person who's being victimized because they feel so bad that they didn't do anything. Like, shut the hell up. You know what I mean? I'm glad he's testifying on her behalf, because the fact that he was there and was a witness and can testify as to what he heard Gallagher saying is very powerful, but like, get over yourself, buddy. You know what I mean?
She got what she wanted that night.
She wanted to be raped.
It's a common women's fantasy, Holmes. Not that like you would know what a woman wants.
The NYPD can't have witnesses
And
working
nobody
undercover.
at the NYPD or my office asked Mr. Holmes to do this.
How did you come to record this?
When Gallagher came into the men's room, I sensed he was going to threaten me, so I hit record.
Permissible under New York state law.
Right, so it is true that this recording would be allowed under New York law. So being able to enter a recorded conversation into a trial depends on the state. Some states are called two-party consent states, which makes it a crime to record or eavesdrop on a conversation, including a private in-person conversation or a phone call, unless you have consent of all the parties that are part of the conversation. However, New York is a one-party consent state, meaning that as long as one party to a conversation consents to the recording, which in this case happened, he was the one who did the recording, then it is not illegal.
Judge Gallagher, you come from a good family, a fine home. And yet, despite all those advantages, upon achieving power, you abused it habitually. So in the interest of true justice for the women you've abused, I hereby order you to serve your 1-year sentence in a jail cell.
What?
It's fine.
You can't do that. We had a deal.
You did. And as you well understand, the bench has inherent powers in these situations. The long arm of the law can work both ways.
He just got a taste of his own medicine.
Would have happened without you, counsel. You were brave to get on the stand.
The women were. I wasn't. What would have been brave if I'd taken a stand 30 years ago.
Oh my God, shut up. Could a judge do that? The guy took a deal with the ADA. He said that he would plead guilty and take the year on house arrest, so isn't that kind of a done deal? No. A judge has pretty wide discretion to a certain extent in these situations, and they can decide that the deal that the ADA or whatever prosecuting body has reached with the defendant is not just for whatever reason. It doesn't fall within the confines of justice or what would be just under these circumstances, and they can decide not to enforce or go along with the deal that the ADA has struck. He can appeal this as an abuse of discretion on the part of the judge. However, it's not like she gave him an obscenely long prison sentence or something. It's still at 1 year. It's just instead of him being on house arrest at home for that year, he's going to be in a prison cell, which isn't a complete departure from the deal that he entered into with the ADA. So it's his success on appeal is questionable at best. He could, however, question the witnesses and the evidence used against him. That's often what comes up on appeal, that they were entered incorrectly, that they were allowed incorrectly, especially like with April and Wentworth, whatever his character's name is, coming in and being a witness against him when it doesn't sound like they were planning on it and maybe weren't disclosed at any point. Like, that's stuff that on appeal he could definitely address. However, with how slow our justice system is working, especially during COVID times, his whole prison sentence will probably pass before he gets anywhere on his appeal. So have fun in prison. I think it's symbolic that it was an older black woman that sentenced him. Chip Gallagher is obviously supposed to be representative of Brett Kavanaugh, a Supreme Court justice who became a Supreme Court justice even after being accused of sexually harassing people. Clarence Thomas in the 90s was also a Supreme Court justice that became a justice despite allegations by Anita Hill, a black woman. There's definitely some symbolism there that they were kind of, I think, pulling on. And I think that this issue is really important. I mean, I was in law school during the Brett Kavanaugh hearings. I was working for the DOJ during the Brett Kavanaugh hearings, so it was all over the place. It was all anyone was talking about. And I think as someone who survived any sort of like sexual trauma, sitting through those hearings was horrible. It was just re-traumatizing on a national level to watch the system work so well and so systematically for a clear abuser in the way that it did, and to have no power in it, and to watch a woman go before Congress and be so brave and talk about her experience and clearly experience new trauma because of coming forward and have it mean absolutely nothing. It's just kind of a slap in the face. Watching that happen was just kind of a confirmation that, like, fundamentally the system does not work in my favor, and there are no consequences for when people in power, men in power, white men in power, abuse that power. They're gonna just get away with it. That's kind of why I went on a rant earlier in this video about like the prestige element that goes with the legal field. That's present in a lot of areas, and the amount of deference we give to prestigious institutions and to the people that come from them leads to this type of abuse of power, because it makes people untouchable in a way that is just unconscionable. Yes, I'm getting on my high horse about it, and I'm on this soapbox, and I won't ever get off of it. So now I'm worked up. Anyway, I hope you found this entertaining, informational, you learned something. If there's a different episode of Law & Order, if I still got it wrong, there's something better you want me to watch, comment below. Please, show me what you want. I enjoyed this episode. It was definitely better than the last one I watched, so like, point taken. It's gotten better over the years. There was an actual court scene in this one as opposed to the last one where there was not one. I get it. Thank you for watching. If you have any questions or suggestions, comment below. Please don't forget to like and subscribe. Thank you so much for watching. Have a good day. Goodbye.